Room. So thank you guys all for coming for this month's webinar. I'm Ashley Lubinsky. I'm the Executive Director of the Firearms Research Center. And today we've got a presentation from Thomas Chittum. And Tom is currently a law professor at the University of Nevada, Las Vegas. But he also had a very long career with the ATF. And I believe, if I'm correct, his last title that he held there before he retired from the ATF was the Acting Deputy Director. So he's got a lot of experience in the topic he's going to discuss today. What we'll do is I will turn it over to him. And as you know, we've got about an hour. And since we're on the webinar feature, if you want to ask questions, we'll have a little time at the end. There's a Q&A button at the bottom. So if you have questions, you can just type it in that Q&A feature. Don't type it into the chat. And once Tom is done, we will take a look and answer what we can. All right, Tom, I will let you take it from here.
Thanks, Ashley. Let me see if I can share, and please tell me when you can see the front page of my presentation.
I can see it.
Okay, super. So thanks to the Firearms Research Center for having me. The topic today is the law of making firearms. Let's see if I can get this to advance. And like any good attorney must, I'm going to start with a disclaimer. Now, the disclaimer, of course, is to say, hey, this is not legal advice. But really, what it's to do is to sensitize you to the fact that this is really a complex, at times hyper technical, and very fact specific area of law. It's also to let you know that most of what I'll talk about today relates to federal law, but I don't really go deeply into things like state and local regulations, zoning ordinances, product safety, civil liability, export controls. There's just really a lot to it. Occasionally, people have this misperception that because the topic of guns seems like a simple issue, that it's not really a complicated area of law. It is. And so I offer that only to orient you towards what we'll be talking about. And with that, I would like to start with some history. As Oliver Wendell Holmes tells us, a page of history is worth a volume of logic. And so if you'll indulge me, the next 5 minutes or so will be a bit of a history lesson in the development of American gun law. Of course, there would be no America without guns. The shot heard around the world was both with firearms, but over firearms as British regulars marched on colonial arsenals. Of course, around this time, the firearms that were being made were custom-made items. They were made by artisans, not manufactured in an industrial process yet. And as long as we have been here and had guns, we've also had gun laws. On the left there is Wyatt Earp. You'll remember the shootout at the OK Corral was also over a firearms regulation, memorialized in my wife's favorite scene in Tombstone when Sam Elliott says you can't carry guns in town. This picture on the right is from Dodge City, and with the help of some enhanced text, you can see there was a sign there that said the carrying of firearms was strictly prohibited. And so we've always had these firearms laws to deal with. Now, if you asked the normal person, hey, what was the first machine gun? Many people will think of the Gatling gun. In fact, under the legal definition of machine gun today, a Gatling gun is not a machine gun. Careful observers who looked behind me will see on the wall I have an image of the patent of the Gatling gun. That was a gift to me when I retired from ATF. Contrary to popular notion, many of the people who work at ATF are firearms enthusiasts. And it was an interesting story. So Dr. Gatling, inventing his gun, he wrote to a friend and said, it occurred to me that if I could invent a machine, a gun that would replace 100 soldiers on the battlefield, I might be able to save lives. Because remember, around the time of the Civil War, more soldiers died from disease than from combat. He was outdone by Hiram Maxim, who made a true machine gun. But contrary to Dr. Gatling's hopes, Machine guns did not reduce the size of armies. In fact, it increased the carnage so much that soldiers had to begin fighting in trenches. And you'll no doubt remember that the land between opposing forces' trenches was called no man's land because the soldier could not cross it without being mowed down by a machine gun. Well, if you looked at the Gatling gun and Maxim's machine guns, they were very large. And so there was a challenge. How do we get into these trenches? Well, enter Colonel Thompson, who invents the first portable machine gun, the Tommy gun, sometimes called the trench broom, originally called the Annihilator. But Colonel Thompson had a problem. He brings his machine gun to market around 1918, and that's when World War I ends. And so he finds himself with a firearm he wants to sell, and the most obvious market, the military, wasn't quite as viable. So he turns to the commercial market, starts selling the Thompson as a firearm suitable for home defense or protecting your ranch. You could buy a machine gun in a hardware store because at this time, there were no federal laws that restricted firearms at all, let alone restricting machine guns. But as a practical matter, these were very expensive, and so they didn't really take off with the general public. They did find some buyers in the forms of law enforcement, but they really sort of got their reputation from the gangsters of this prohibition era. And so this is, sometimes people will say the Tommy gun was the gun that made the 20s roar. Now, thankfully, America came to its senses. We repealed the prohibition. The liquor started flowing again. But by this point, we had some gun crime issues that the public expected Congress to deal with. And so this led to the passage of the first major federal firearms law, the National Firearms Act. There was an earlier federal firearms law, non-mailable firearms, passed in 1927, but we'll talk about the NFA as the first major federal law that will affect making of firearms. Now, the NFA only dealt with a small category of firearms. I'm going to talk at greater length about what those are. You can think of them as gangster guns. That's not a legal term, but it helps you conceptualize what the NFA was trying to get at. Things like machine guns and silencers and short-barreled shotguns. We'll talk more about that in a moment. So then some more history. In the 60s, of course, JFK was shot and killed by this man. You've no doubt seen this picture of Lee Harvey Oswald holding his Italian Carcano rifle. You may not have noticed before that in his pocket he has a revolver. On the same day that he shot and killed the president, he also shot and killed a Dallas police officer, J.D. Tippit, with that revolver. And Oswald bought both of those firearms through the mail using an alias. It's also worth noting that at one point, Oswald attempted to renounce his citizenship, attempted to renounce his American citizenship. He was not effective in that, as is typical with the federal government. There's a form for that. He didn't fill out the form, but that will be important in a moment. Now, of course, Lee Harvey Oswald was shot and killed by Jack Ruby shortly thereafter using a gun that was purchased in what today we would call a straw purchase. Not because Ruby couldn't buy the gun, but because he wanted to get a discount. He asked a police officer friend of his to buy it. A few years later, at the University of Texas in Austin, Charles Whitman climbed a clock tower and shot and killed a number of people. We would come to find out that Whitman was having mental health issues. He was a former Marine. A few years after that, Dr. Martin Luther King Jr. was killed by an escaped racist. James Earl Ray had escaped from a Missouri prison, so he was a fugitive. He bought a rifle and used it to kill the civil rights leader. And then shortly thereafter, Bobby Kennedy was killed by Sirhan Sirhan, a Jordanian citizen. And so all of these events and other events too led Congress to pass the second major gun control law, the Gun Control Act of 1968. Now, the Gun Control Act of 1968 is really an expansion of some legislation that was passed earlier, the Federal Firearms Act of 1938. But for practical purposes today, we'll just go with these two major laws, the NFA of 1934 and the GCA of 1968. Now, you'll see here through the magic of PowerPoint, if you'll watch that badge, the Gun Control Act and the NFA were assigned primarily to the Bureau of Alcohol, Tobacco, and Firearms to enforce. ATF has its own interesting history that goes beyond the scope of the presentation today. But if you'll watch here, ATF moved from the Treasury Department to the Department of Justice. That's where it sits now, has sat there since 2003. And explosives was added to the agency's name. It retained the acronym ATF, but it's been the Bureau of Alcohol, Tobacco, Firearms, and Explosives since 2003, so more than 20 years. So reading these two laws together, we can come away with a summary of federal gun law. What it does is it controls types of weapons. It prohibits classes of people from possessing firearms. It regulates commerce, meaning it requires things like licensing. It controls how transfers are done. It implements inspection activities. It criminalizes certain acts like manufacturing firearms without a license in some cases, as I'll describe. But one important thing about the Gun Control Act especially, Congress isn't always clear with its intent. But with the Gun Control Act, it actually was very clear. In a preamble, it said the purpose of the Gun Control Act is to assist law enforcement in the fight against crime and violence. It also said what the intent wasn't. The intent is not to impede the lawful activities of law-abiding citizens. And so that's actually in the law. It was never codified, but if you look at Section 101 of the Act, it actually includes that in there. And so Congress intentionally left a lot of activities outside the scope of federal law. It does not regulate a lot of private activity, which we'll talk about. And of course, there are the 50 states, and things can vary widely across those. So if you're thinking in big buckets, you can drop gun violations into four big buckets: prohibited persons, prohibited firearms, prohibited acts, and prohibited places. Now, we won't talk much about prohibited places today, although it can have some relevance to manufacturing, for instance, state zoning rules that may limit where firearms could be manufactured. Mostly we'll talk about prohibited persons, firearms, and acts. So let's proceed with that now. Prohibited persons. Most people know that convicted felons cannot possess firearms. Here is public enemy number one. And you might ask yourself, well, why is that relevant to a presentation about making firearms? Well, if you are a prohibited person, you cannot make a firearm because once made, you would possess it, and that would put you in violation of the law. You could also not employ prohibited persons. So if you started a firearms manufacturing business, you could not employ, say, convicted felons in your business because you would be placing them in violation of the law too. Convicted felons are the most commonly known type of prohibited person, but there are others. And so the primary law we're talking about here, 18 U.S.C. 922G, actually includes 9 categories of prohibited persons. The first is someone who's been convicted of a crime punishable by more than 1 year. But look at these other categories, and what you're going to start seeing is threads from the history we talked about. Just like James Earl Ray being a fugitive from justice, or Charles Whitman having mental health issues, or the renounced citizenship that Lee Harvey Oswald attempted to do. Now, these other categories, domestic violence restraining order and misdemeanor crimes of domestic violence, those were added later as Congress realized that there was a real close connection between a history of domestic violence and misuse of firearms. And so it imposed some pretty strict restrictions there. And so if you had, say, a gun manufacturing business and you had an employee who was not prohibited, but then became subject to a domestic violence restraining order, they would be prohibited during the pendency of that restraining order. So now let's talk about prohibited firearms. And you'll see my little asterisk up there. These firearms are not necessarily prohibited. I use prohibited for the easy label and to be consistency, just for it being memorable. Really, what you should call these, I think, is restricted, regulated firearms. Now, you'll see this picture. This is Han Solo's phaser. This is your first reminder that you should sign up for the Firearms Research Center's forum. I actually took this image off of a story that Ashley wrote about the historical underpinnings of some of the firearms that made their way into the Star Wars movies. One other point too, along the bottoms of some slides, I've cited to various statutes or court cases. I prepared a supplement outline that goes along with this presentation, and in it, I've got hyperlinks to a lot of these things. You'll find it on the webinar page. So back to the National Firearms Act. Remember that I said the NFA deals with a narrow category or narrow categories of firearms. The NFA defines firearm in the law. Now, this is confusing because when it uses the term firearm in the context of the NFA, it's really a term of art because it doesn't mean firearm in the general sense. It means firearm in the very specific sense of NFA type firearms. And so the first category there is a shotgun with a barrel of less than 18 inches. Or what is often called a short-barreled shotgun, or abbreviated in SBS. Also, a weapon made from a shotgun if less than 26 inches overall. Now, what is the difference between a shotgun and a weapon made from a shotgun? Why make that distinction? Well, because the law specifically defines shotgun as a weapon intended to be fired from the shoulder. So if you saw the stock off or you remove the stock, it's no longer intended to be fired from the shoulder. So now it's a weapon made from a shotgun. So if a person sawed off the back stock of a shotgun and its overall length was less than 26 inches or its barrel was less than 18 inches, it would be a firearm under the NFA. There's also a similar category for rifles, although the barrel length is different, 16 inches, and same thing, weapon made from a rifle. There is a category called any other weapon, which doesn't literally mean any other weapon. For all intents and purposes, this is a category that encompasses things like disguised weapons, a firearm concealed in a cell phone or a cane. Interesting, this is your second reminder to sign up for the Firearms Research Center Forum. I recently wrote a article that will be published in the forum next week, and I talk a little bit about the history of this term, AOW. Then there is a machine gun. We'll talk a little bit more about machine guns in a moment. And silencers, we'll talk more about them. And then there's a category called destructive devices. And this is a broad category. It includes things like pipe bombs and Molotov cocktails, but it can also include firearms that do not have a sporting purpose with a barrel of greater than a half inch. And you think, well, what in the world might that be? Well, ATF has classified things like the street sweeper shotgun as a destructive device. So a street sweeper shotgun has to be registered the same way a silencer or a machine gun or a short-barreled shotgun does. And with the exception of 410s, essentially all shotguns have a barrel of greater than a half inch in diameter. Now, again, these are not necessarily prohibited. I use that term for simplicity. What it means is it's unlawful to possess one of these firearms if it is not registered in the National Firearms Registration and Transfer Record to the person who possesses it. So it's unlawful to possess one of these firearms if it is not registered to you. So let's talk specifically about machine guns. Pet peeve of mine, machine gun is one word. Watch for an upcoming article about that too. Um, the NFA actually defines machine gun, and you'll see here's where it's defined. Now, if you look, this is in Title 26. The NFA is in Title 26 of the U.S. Code. That is the tax code, and that's because the NFA is a tax law. That's probably part of the historical function of when it was first passed. For those attorneys in the audience, you may recall the Lochner era when it wasn't entirely clear the full extent of Congress's commerce power, but its tax power was very clear. And of course, Al Capone had just been convicted of tax evasion. And so it was probably the first and last time that taxes were popular. But the NFA was passed as a tax law, and it still sits there today. Under Section 5845B, machine gun is defined as any weapon which shoots, is designed to shoot, or can be readily restored to shoot automatically more than one shot without reloading by a single function of the trigger. Why not a single pull of the trigger? Well, because then it would be easy to evade by creating a push trigger. The law also defines the frame or receiver of a machine gun as a machine gun in and of itself. So even if you took that machine gun and you stripped it down of all its parts, and all that you had left over was the frame or receiver of that machine gun, it would still be a machine gun subject to the regulations of the NFA. So if you started a manufacturing business and you say, I'm not going to completely manufacture full machine guns, I'm just going to stop once I have the frame or receiver, you would still be making a machine gun under the law. And then later, the NFA was amended to also include any part or combination of parts designed and intended for use in converting a semi-automatic weapon into a machine gun. Now, that has important relevance for today. We'll talk about that in a moment. Now, in 1986, New Jersey Representative William Hughes added what has come to be known as the Hughes Amendment to the Firearms Owners Protection Act. The Firearms Owners Protection Act was overwhelmingly a right-leaning piece of legislation that was intended to provide some protections, as the name suggests, for firearms owners. And Representative Hughes proposed the Hughes Amendment that many people believe was a poison pill, was intended to sink the legislation. It did not sink the legislation. It became law. And what it did was ban all new machine guns. So no machine gun manufactured after May 19th, 1986 may be transferred to a private person. Now, machine guns can still be made today for government use. So if you wanted to go into business as a machine gun manufacturer, there's still a market you could sell into, but it's only the government market. You can't sell any machine gun made after 1986, May 19th, 1986, to a private person. That will have some consequences. So the NFA was passed, as I mentioned, in response to this rise in crime associated with prohibition. It was passed in 1934, and it was incredibly effective. By the end of the 1930s, those machine guns that were in circulation were basically no longer in circulation. They were registered or seized by police, and it was very effective. Machine guns weren't used to commit crimes for a very long time. Any of the machine guns that were still in circulation were basically possessed by law-abiding people, and they were almost never used. But around about 2019, there became a proliferation of small devices that could easily convert a common Glock handgun into a machine gun. And here's an ATF agent demonstrating a Glock that has been converted to fire fully automatic. These devices are often called machine gun conversion devices. You'll see it abbreviated MCD, or sometimes they're called Glock switches. So, not since Prohibition had we seen so many machine guns being used to commit crimes, often violent crimes. And so you'll remember the definition of machine gun in the NFA includes not just machine guns, a weapon intended to fire automatically more than one shot, and not just the frame or receiver, but any device intended for converting it. So all of these items on the right are that. They are devices intended for converting semi-automatic firearms to fully automatic firearms. So each of these items in and of themselves is a machine gun subject to the same criminal penalties for possession. Now, when I first developed this making guns presentation, I delivered it at a manufacturing conference. It was an abbreviated version, but with the proliferation of 3D printers, more and more people are able to print little doodads like this. And when people refer to them as Glock switches, that gives the perception that, well, Glock is a legitimate firearms manufacturer. This must be a lawful device. I found it very easily. And so I always try to emphasize that manufacturing even one of these apparent innocuous doodads is a very serious offense under federal law because it, in and of itself, is a machine gun. Now, I mentioned that there were consequences to the Hughes Amendment. So in 1986, the inventory of legally possessible, legally transferable machine guns was frozen. No new machine guns could be made for the private market. So, what is the one law that machine guns do not violate? The law of supply and demand. As the supply of legally transferable machine guns dwindle, as more and more of them permanently go off the market, the price of that available supply goes up and up and up. So if you were to try and buy a pre-86 registered machine gun today, you're talking tens of thousands of dollars. There are a lot of people that would like to shoot a machine gun for the sheer thrill of it. And so what happened was inventors innovated and developed devices that mimicked machine guns. Now, most people think a machine gun's defining characteristic is how fast it fires. But that's not how they're legally defined. Legally, a machine gun is defined by the mechanics of how it works. It has to fire automatically more than one shot from a single function of the trigger. That doesn't necessarily mean fast. Of course, most machine guns are fast. But simply shooting fast does not make a thing a machine gun. And so one of the first accessories that was developed to mimic this high rate of gunfire was a thing called a bump stock, where you replace the stock on a standard semi-automatic rifle. And what it does is has a channel that allows the firearm body to move back and forth. And by applying pressure forward on the firearm and holding your finger static on this bump stock attachment, the gun rocks back and forth rapidly, driven by the recoil of the firearm. And what it does is functionally allows your static finger to pull the trigger over and over and over again as the device rocks back and forth. Now, most of America had never heard of a bump stock prior to this awful mass shooting in Las Vegas. Then everybody had heard of bump stocks. And what the president did was direct the ATF to reclassify bump stocks as machine guns. Bump stocks were not new to ATF. ATF had examined them in the past, rendered an opinion that they were not machine guns because the trigger was still technically being pulled. But when the president tells you to do something, you do it. And so ATF reclassified bump stocks as machine guns. It wrote a rule that said, yeah, we interpret this now as being automatically more than one shot with a single function of the trigger. Well, this, of course, made its way up to the Supreme Court in a case called Garland v. Cargill. The Supreme Court said that ATF overstepped its authority. It was wrong, and bump stocks were not machine guns under the law. Now, bump stocks are not the only device that have been invented to mimic the high rate of gunfire that a machine gun offers. For instance, one of the newest is a thing called a forced reset trigger. And there has been an ongoing saga between ATF and the inventors and manufacturers and producers of these items. ATF was of the opinion that forced reset triggers, or FRTs, were in fact machine guns. The manufacturer objected. They litigated. And recently, the Department of Justice has announced that it has tabled this. It reached a settlement with one or more of the manufacturers. The full fallout of that is still to be determined because the settlement agreement only applied to certain manufacturers, and I've seen now some patent litigation going on. So this is an issue to watch. One of the other categories of the NFA that is particularly prominent today are silencers. Now, the industry mostly calls these suppressors today. And I think that that is sort of a recognition that silencers do not actually silence guns. They reduce the sound of the report, but they do not silence them. I continue to use the term silencer because that's how the law defines them, and because it's been a historically prominent title. This one, what is this? Your third reminder to sign up for the Firearms Research Center's forum. I attended a Works in Progress conference at the University of Wyoming last year, where I presented a paper that I wrote on silencers. It should be published actually in the next couple of weeks, but a brief blog post about my article was published in the forum. You can find it in there. It's The Firearm That Isn't Silencers and the Loud Bang Theory. And the reason I call it that is because under the law, you'll remember, a silencer is a firearm, a legal firearm, both under the NFA and under the GCA. So even this tube here with its baffles in it, which cannot shoot, could not hurt you by itself unless somebody bashed you over the head with it. Even it by itself, unattached to a gun, is a firearm under the law. Now, increasingly, advanced manufacturing techniques, especially like 3D printing, powder bed fusion, makes it easier to produce these things. But because they are firearms, they are subject to certain restrictions, which we'll talk about in just a minute. Now, there is a long public perception that silencers somehow facilitate violent crime. That's actually a big part of the article that I wrote, actually tracking whether or not that was true and why silencers have the reputation that they do. But what we know is they have experienced a renaissance. So this is the growth of registered silencers in the U.S. market. These statistics are a couple of years old now, but you can see they have experienced tremendous growth. And that's in large part because of the growing recognition that they provide considerable health benefits. After years of shooting, many people, yours truly included, have started to experience hearing problems because guns are loud. And so even though guns have improved in every single respect since the founding, they're lighter, they're more durable, they're more accurate, they're not any quieter. And that loud noise can be harmful. And because of that, silencers have grown in popularity, which represents a real market opportunity for somebody who can design a better, cheaper, or more durable silencer. For a very long time, their restriction under the NFA basically meant that there was very little invested in research and development. And so I think what you're going to see is the silencer market is going to continue to grow. The designs will continue to evolve and improve. Especially because the One Big Beautiful Bill Act made it more affordable. So I mentioned to you that the NFA did not actually ban firearms. What it did not ban NFA firearms. What it did was require their registration and a tax. And between 1934 and 2026, that tax was a steady $200. $200 in 34, $200 in 2025. It's the only thing that resisted inflation. But with the One Big Beautiful Bill Act, the tax for short-barreled shotguns and rifles and silencers and any other weapons was reduced from $200 to $0. AOW's had a $5 tax in some circumstances, but it's $0 too. The transfer tax on a machine gun or destructive device remains $200. Now, immediately upon this change in the law, there were lawsuits that said, well, wait a second, if the NFA is entirely predicated on Congress's power to tax, and now that tax is $0, it's not a tax at all, and therefore you have eliminated the constitutional basis for the NFA, and therefore the NFA is unconstitutional. That litigation is ongoing. But as it stands right now, there is no cost to manufacture or transfer a silencer or short-barreled shotgun. Now, we've been talking a lot about the NFA, and I reminded you that the term firearm in the NFA is a term of art, right? It just means that narrow category. The same word, firearm, is defined differently in the Gun Control Act, and it is much broader. It is here any weapon, not any device, not any doodad, not anything, any weapon. And so you must start from that. Is this thing a weapon that's designed or may readily be converted to expel a projectile by the action of an explosive? The same as the NFA, it includes the frame or receiver of any such weapon. Here again is where the Gun Control Act says a silencer in and of itself is a firearm, and so is a destructive device. But interestingly, the definition of firearm specifically excludes antique firearms. So an antique firearm is not a firearm for purposes of the law. What is an antique firearm? Well, it's one that was made in or before 1898. I don't know why they didn't just say before 1899. I assume it's because some lawyer was being paid by the word when he proposed this legislation. But any gun made in or before 1898 is not a firearm under the GCA. It could technically be a firearm under the NFA. That's a different thing. Or the replica of any matchlock, flintlock, percussion cap, or similar type of ignition system, or any muzzle-loading rifle, shotgun, or pistol. Okay, so now I'd like to play a game I call Gun or Nah. I'm going to show you some items. I want you to think about whether or not it is a gun under the law, a firearm. First, this. This is a replica of a Kentucky long rifle. Careful observers will see behind me on the wall, I have this exact item hang on my wall as a retirement gift. This, because it is a replica of a antique ignition system, is not a firearm. But what about this one? This is a modern inline muzzle loader. Is this a firearm? Well, this is your fourth reminder to sign up for the forum newsletter because I wrote an article that talks about the interesting legal history of the definition of firearm, and it talks specifically about a court case involving the Night Disc rifle, which for a while was a firearm because ATF said it was, and a court agreed with it, and then it wasn't because Congress changed the definition of firearm. What about this? This is the Taser 7. Is it a firearm? Nah. It uses compressed air to expel its projectiles. And you'll remember the definition of firearm means one that uses an explosive to expel the projectile. But what about the Taser 10? Yes, it uses gunpowder to expel its projectiles, which means it is a weapon that expels a projectile through the action of explosive, which means for purposes of selling the Taser 10, Axon must have an FFL and follow all those rules. Now, what about this device here? No, this is a jet injector for inoculations. Why did I include this, aside from the fact that it sort of looks like a gun? Because this is a medical device and it has to be pre-approved by the FDA before it hits the market, which distinguishes that sort of thing from firearms because ATF does not have that same sort of pre-market authority. So if you want to manufacture a firearm, there's nothing in the law that says you must get ATF's classification in advance. Now, you have to be licensed, and we'll talk about that in a second. But if you decide to go to a market with a firearm, you can decide for yourself how you think it should be classified. There's a risk to that, though. You can ask the ATF, hey, will you give me a classification? And ATF will say, I've looked at the gun and I think it's this or that. I think it falls under the NFA or the GCA, or I think it's not a firearm at all. If you go to market and start selling the item and ATF finds out about it and disagrees with you, it may approach you with a cease and desist. Hey, we think what you're doing is incorrect under the law. Here's an example with the forced reset triggers. Sometimes ATF will issue an open letter telling the whole world, hey, this is our opinion. You'll see this is the open letter on the Franklin Armory Reformation and Antithesis firearms. Franklin Armory has a really interesting history of innovating clever designed guns that stay within the letter of the law and really challenge ATF's interpretation and application of the law. Sometimes ATF will engage in formal rulemaking, which is a laborious and time-consuming process. But without many other options, sometimes ATF defaults to the biggest tool in its toolbox, and that is its law enforcement authority. And so if a person was selling a thing that ATF thought was, for instance, a machine gun, and wasn't registered under the NFA, ATF would interpret that. It might treat it as if a person had an illegal machine gun. That has caused a lot of issues. So now we come to the last category, prohibited acts. The law requires a person who is engaged in the business of manufacturing firearms to be licensed. What does it mean to be engaged in the business? Well, it's a person who devotes time, attention, and labor to manufacturing firearms as a regular course of trade or business with the principal objective of livelihood and profit through sale and distribution. That's a mouthful, right? This does not draw a bright line. Only if you're engaged in the business of manufacturing do you need to be licensed. In that case, you're getting a federal firearms license. You'll be a federal firearms licensee or an FFL. You'll apply to the ATF for it. And you'd have to be licensed. You'd have to follow the regulations. That requires you to keep some paperwork. For the firearms that you manufactured, you're required to place certain markings on them. Most notably, the serial number must be placed on the frame or receiver. ATF has promulgated a regulation that describes the depth and size of those markings. Unlike prints, you can't just use a symbol. It says you've got to use Roman numbers and Cyrillic letters to describe the serial number. You can't repeat them. And here are the other markings that you'd have to put on your firearm too. If you are a licensed manufacturer, you'd also have to keep some records. Now, some of these records are for dealers, but you get the point. For instance, you'd have to report annual productions, and you'd also have to make payments. So when ATF moved from the Treasury Department in 2003, this was part of the Homeland Restructuring Act, it cleaved off part of ATF and left it behind in the Treasury as the Alcohol and Tobacco Tax and Trade Bureau. Goes by TTB. TTB still collects firearms and ammunition excise tax. If there's some small comfort in this tax, it is that it goes to a good purpose. The U.S. Fish and Wildlife Service administers the Pittman-Robertson Act, and a lot of those excise taxes go back into conservation efforts in the term of billions of dollars. They've done a lot of good. Now, reasonable people can disagree about classifications. One example landed before the Supreme Court, U.S. v. Thompson Center, where Thompson was marketing its contender, which could be swapped out as a kit. And it had a stock and a long barrel in the kit too. So if you wanted to convert your Thompson Contender pistol into a Thompson Contender rifle, you could just put on the stock and replace the long barrel, and boom, you've got the Contender rifle. But ATF said, well, wait a second. If you put the stock on, but you didn't replace the barrel, you would have created a short-barreled rifle, and that's an NFA item. And so to resolve this, Thompson paid the $200 tax and then sued the federal government to get its $200 tax back. Now, this wasn't really a tax case. This was a device to get this into court, and Thompson won. And the Supreme Court said, ATF, you're overreading this. We apply the rule of lenity. And so there is a way to resolve these things, but it can be costly if you're going into market. So these are the sorts of things you'd have to think about. Now, privately made firearms, or PMFs. This is my hands on 60 Minutes. I did a piece on 60 Minutes. They, of course, called them ghost guns. That's a common term that many people use. The government uses the more innocuous privately made firearms. And the reason is, remember way back when we talked about the Gun Control Act, and I said Congress intentionally carved out certain things? Well, Congress has long left alone the private transfer of firearms. It does not regulate the private transfer of firearms. And in the same way, it doesn't regulate the private making of firearms. So you as a person can make a firearm if you want. The government doesn't regulate that. The thing is, some businesses got into the market and started selling these complete kits, a gun in a box with a little bit of machining. You could use all the pieces in the box and you could assemble a complete and working firearm. So ATF rewrote its rules, the regulatory definition of framer receiver, to include a complete kit. And the Supreme Court, in a case Bondi v. Vanderstock, upheld ATF's regulation. Now, what it said is, look, this doesn't draw the line, but it draws a line. So there's still an open question about, well, how complete must a kit be before it qualifies as a firearm? So when people think about these privately made firearms or ghost guns, a lot of times what they're thinking about is 3D printed guns. Can you 3D print a gun legally? Well, federal law doesn't care how you make a gun. You can print it with a 3D printer. You could carve it from a piece of stone. It doesn't care. However you make it is irrelevant and does not matter to the federal government. And so 3D printing is fine. Now, subject to all of the other restrictions that we've talked about. So if you 3D printed, say, a machine gun conversion device, you would have created a firearm that has to be registered. And so that's a violation in and of itself. But just to create a GCA type handgun as a private person is unregulated. Now, some states may require you to place some markings on that firearm, but federal law doesn't require a private citizen making a personal gun to engrave a serial number on it. That said, there is a law, the Undetectable Firearms Act. This is not what it really stands for, but this is how I remember the statute. 922P, I think P for plastic, right? You cannot make a gun that is not detectable by a magnetometer. And so when some of these early plastic printed, 3D printed guns were made, they have a metal insert that must go into them. I cannot think about this law without thinking about this scene from the movie In the Line of Fire. If you haven't seen it, do yourself a favor and go and watch it. John Malkovich was awesome. All right, so now you've got a lot of information. Let's run through a couple of quick Q&As. Let's say I want to make a pistol for personal use. Well, the first question, are you a prohibited person? Oh, let me remind you, this is not legal advice. Are you a prohibited person? If you're a felon, you can't make yourself a gun. There are no federal restrictions or requirements otherwise, but there may be state law requiring marking or registration, that sort of thing. Let's say you want to make a silencer for personal use. Well, are you a prohibited person? Same thing. A silencer is a firearm under the law. Does your state permit it? If it does, then what you would do is submit a Form 1 to ATF, an application to make and register a silencer. Let's say I want to make a machine gun for personal use. You can't. I want to manufacture firearms for sale. Not for personal use. Now I want to make them for sale. Well, you must be licensed by ATF. You may also have to be what's called a special occupational taxpayer. That's an additional license for those who are making NFA weapons. You may also have to comply with some state regulations or licensing requirements. And let's say I'm a subcontract manufacturer for FFL. I'm just making some part for them, or I'm doing some process to the gun. Well, in that case, I hate to sound like a lawyer, but it depends. It might require a license from ATF. It just depends on the circumstances and whether the part of processing that you're doing qualifies as manufacturing or not. What if I don't follow all of these rules? Well, here's the interesting thing. When these rules were made, when the NFA and the Gun Control Act were passed, they were passed as crime control legislation, not manufacturing regulations. Yes, they regulate manufacturing, but that wasn't really how they were designed. And because of that, sometimes it's like trying to fit a square peg into a round hole. And so the punishment isn't like, oh, I made a mistake on my taxes. It's imprisonment. And so you really do have to tread carefully when you're dealing with manufacturing firearms. Where can I go for more information? Well, I really encourage you to go to ATF's website. There is a ton of information on there, atf.gov. You can also go to ttb.gov if you want to read about firearms and ammunition excise tax. I have links to both of those in the supplemental outline. And of course, you can always reach out to me. Here's my contact information. I am not yet a LinkedIn influencer, but I do like writing about these things on LinkedIn. That little QR code will take you right to my profile. If you're interested, I'd love to get connected there. And that, in a nutshell, is the law of making guns. Let me stop sharing.
Thank you
All
so
right.
much, Tom. I just want to say for the record, I did not pay him to tout our forum page as much as he did. But if you want to check it out, firearmsresearchcenter.org, we appreciate you. And we're always looking for people to contribute from a range of different backgrounds. So if anyone listening here wants to do something for our forum, definitely reach out to us. As Tom mentioned, he's done a bunch for us over the past year or so. All right, so we already have one question. As a reminder, if you have any questions, we've got like 5 more minutes. Just type your question into the Q&A. The first one's from Andrew, and his question is, how does 922 G1 work for a corporate entity convicted at the corporate level of a felony offense? And the example was a gun manufacturing firm convicted of corruption. And then just to mention that he knows that the initial impetus for adding the restoration provision to the GCA, but was curious if there's any recent law or developments in the area.
So I should be careful trying to shoot from the hip, no pun intended, on that answer. So, as Andrew points out and may know better than me, all right, even though for a very long time ATF was denied the ability to restore rights for individuals, that existed for corporations. Now, of course, the department is revamping the restoration of rights entirely. I don't know exactly. What I do know is occasionally licensees will be, let's say, revoked. They will be inspected by ATF. A willful violation, I didn't get into it, but willful violations, as distinguished from knowing violations, may lead to license revocation. And if a license has been revoked, then a person could not simply get a new one. ATF will look for a disguised ownership. But for a corporate conviction, the long term consequences, I'm going to have to look into it. I'll add that to my queue of things to research, Andrew.
All right. Does anyone have any other questions? Oh, what about the ram set used in construction?
I don't know what a ram set is,
Me
so
neither.
I can't answer that. Although I will tell you, so I made the point I think in passing, but in the definition of firearm, it starts with a weapon designed to do this. And so there are plenty of things that expel a projectile by the action of an explosive that are not firearms. For instance, signaling devices. If you had the Batman thing on your belt that would fire the grappling hook up, if it was not a weapon, it would not be a firearm. And so I don't know what a ram set is.
I just Googled it so I could, so
Is it
according
a
to, it's a powder actuated tool used in construction to fashion or fasten materials like wood or metal directly to concrete, masonry, or steel by
yeah?
using a 22 caliber charge to drive specialized hardened steel fasteners. It eliminates the need to drill holes, significantly increasing efficiency.
My guess is there is somewhere written that that is not a firearm. I've never researched it specifically, but I would start from the supposition that it is not a weapon, and so it cannot be a firearm, even though it expels a projectile by the action of an explosive.
Oh, sorry, I didn't see that people were. Somebody asked if a nail gun was a firearm.
My guess is no.
What about the private transfer of PMFs?
So again, federal law carves out private transfers. So even though this is surprising to people, there is nothing illegal about one person transferring a firearm to another person, with some limitations. You can't transfer a firearm to a person you know or have reason to know is prohibited from possessing it. So if you think they are a felon, you can't sell it to them. You can't transfer a firearm to a person who's not a resident of your state. But otherwise, federal law does not obligate a private citizen to record that transfer. So if you meet a guy named Bob at the gas station and say, Bob, I have this handgun and I'm tired of having it. Would you like to buy it? You sell it to him. That in and of itself is not illegal. Now, a lot of states have pushed and passed universal background check type legislation. So you do need to be careful about how you transfer firearms. But as a practical matter, transferring a firearm, even a privately made one, is not a regulated activity unless you did it at a level where you were engaged in the business. And that is not a bright line definition. And so, if you manufactured even a small number of privately made firearms and you sold them hoping to make money, ATF may interpret that as you being engaged in business, and you could be prosecuted for dealing in firearms without a license. But those are all very fact specific inquiries.
All right. So as long as you're okay to go a few minutes over, we've got a couple more questions. And then somebody did say, I think this is probably in response to Andrew, but Stag Arms CEO was convicted of being in possession of unregistered machine guns, et cetera, was punished with a $100,000 fine, 2 years probation, and agreeing to step down from his company. So it likely depends on each case and circumstance. All right. So the next question is, can pre-1968 machine guns that have been demilitarized be reinstated by the ATF and thus introduce more pre-1968 machine guns into the market?
Well, it was 1986 is when they were banned. And no, I mean, that number is
Yeah.
frozen. If it was not a machine gun and registered on May 19th, or before May 19th, 1986, it's done. There's just no good way to do that short of repealing that prohibition. I have not seen a lot of concerted efforts to do that. Maybe somebody will eventually say, hey, it's unconstitutional, we'll win some court cases, but recent court decisions have upheld it. And so, no, that pool of pre-86 transferable machine guns is pretty static.
All right. And then we've gotten a few more questions. I would say no more new questions, and we'll answer the rest of them. And if you have any other questions, Tom had his information up there. I don't know, Tom, do you want to share your screen again just so people can write down your info if they have further questions?
Well, I'm pretty easy to find. Just Google Tom Chittum. But fair warning, there, as shocking as this is to me, there are two Thomas Chittums in the world, and one of them writes about the coming race war and World War III. That's not me. I'm the other one, the one who was the ATF agent. You can find me online.
Okay, cool. So a question, how does the subcontracting work with suppressor parts for needing an FFL?
Well, that's probably its own discussion. As I mentioned, ATF has offered some guidance on when you, as a sub manufacturer or subcontractor, may have to be licensed. I wouldn't want to just shoot from the hip and answer that, but you should proceed carefully if you are making components to a silencer.
All right, two more. But Mike, just so you know, this is eligible for CLE credit. All right, so can you share your thoughts on the distribution of 3D printed gun files on the internet?
It's too new for me to really have an opinion on that. I did see, although I have not read the opinion yet, that there was a recent case, maybe the Third Circuit on that. I actually have it open on my computer to read, but I just haven't got to it. So maybe some of you all have heard this comedian, Mitch Hedberg. He was awesome. Unfortunately, he died before his time. He used to have a joke where he'd say, I'm tired of chasing my dreams. I'm just going to find out where they're going and catch up with them later. Sometimes that's how I feel about gun law. It is so hard to keep abreast of all the evolving issues that it really can be challenged. So I haven't read that yet. I don't know what the rules are about it. It surprises me a little bit because it feels like it probably intrudes into some First Amendment issues there, but I wouldn't want to say more.
And then the last question is, why aren't state rules overruled by Bruin?
Oh my goodness, I teach a whole course on that. I don't think I could answer that in the time we have left. It will continue to evolve.
All right. Well, thank you so much, Tom. And thanks to everyone. This was a really active and exciting conversation and discussion we had at the end. So I really appreciate you guys engaging with it. As always, we've been recording this, so we will post this online. So if you missed any piece of it or you want to go back and find something, it'll be on our video library at firearmsresearchcenter.org. Thank you guys. And thank you, Tom, again. And have a good weekend.
Thanks, Ashley.